Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about remedies for orders of protection. We've done a whole series of videos and articles on Illinois orders of protection, so for some foundational information you may want to check out Illinois Orders of Protection Explained. That's a good starting point. And also How to File an Order of Protection. Those are two videos and articles that are on learn-about-law.com. So what is an order of protection? An order of protection is a court order that is intended to prohibit future abuse of the petitioner by a family or household member. In order to get an order of protection, there must have been past abuse by a family or household member. You should understand that the definition of abuse is very broad. It can include threats, manipulation, harassment, and we have a video on what constitutes abuse. So it doesn't have to rise to the level of physical abuse. And also the definition of family and household member is very broad. It can include past dating relationships or past communal living arrangements, and it doesn't necessarily have to be your spouse in order to qualify for an order of protection. So even if you don't think on its face you might qualify for both of those terms in order to receive an order of protection, they might be broader than you think. So it's worth checking out our past videos to look into that, because you might qualify. So today we're going to talk about, if you are successful in obtaining an order of protection, what the different remedies are that the court can order and how those work and how the court makes those decisions. There's a couple of big ones that we're going to go into detail about. One is exclusive possession of a shared residence. Another is stay-away orders. And then we're going to talk about some miscellaneous remedies that are within the court's power to order and how they decide whether to order those. But let's first talk about exclusive possession of a shared residence. When ordering exclusive possession, a court is prohibiting the respondent from entering or remaining in a residence that the respondent shares with the petitioner. And they can do this even if the respondent owns or leases the premises on his or her own or jointly with the petitioner. In order to be awarded exclusive possession, the petitioner has to have a right of occupancy to the residence, even if it is jointly owned or leased with the respondent. So the threshold question is, who has a right of occupancy in the premises? Does the petitioner have a right of occupancy in the premises in order to get the possibility of an order of exclusive possession? So a person has a right of occupancy in the premises if it is solely or jointly owned or leased by that person, owned or leased by that person's spouse, owned or leased by a person with a legal duty to provide for him or her or his or her minor children, or owned or leased by a person who has granted them authority to live in the premises, anyone other than the respondent or the opposing party. So if any of those things are true, then even if you don't own the place, or even if your name isn't on the lease, you have a right of occupancy of the premises. And if you're the petitioner, then you may be able to get exclusive possession of the premises, even if the respondent also has a right of occupancy. So let's talk about how, if both parties have a right of occupancy of the premises, how courts determine whether to award the petitioner exclusive possession of the premises and basically kick the respondent out even though they have a right of occupancy. When both parties have a right of occupancy to the premises, the court will perform a test called balancing of the hardships. The court will weigh the hardship of the respondent having to move and leave the premises against the risk of future abuse by the petitioner or other protected parties at the hands of the respondent. If the court finds that the risk of future abuse outweighs the hardship of the respondent moving, then the court will award exclusive possession of a shared residence to the petitioner and require the respondent to vacate the premises. If the court finds that the hardship of moving outweighs the risk of future abuse, the court might order the respondent to financially provide for the petitioner to find a different place to live. They'll look at different things like work location and school and availability of housing. There's a lot of factors they look at when determining the hardship of moving. And obviously the risk of future abuse, you look at the track record. So one thing to keep in mind is that the presumption is in favor of the petitioner getting exclusive possession. So the burden is on the respondent seeking not to have the petitioner have exclusive possession of the residence to show that the hardship of his or her moving outweighs the risk of future abuse. It's not a level playing field. There's a presumption in favor of giving exclusive possession of the petitioner. The other thing to keep in mind is that courts won't even bother with the balancing of the hardships test unless both parties have a right of occupancy. So if the petitioner doesn't have a right of occupancy, they don't even get in the game for exclusive possession. If the respondent doesn't have a right of occupancy, then the court doesn't need to balance the hardships. The court will just award exclusive possession to the petitioner. So that's really all you need to know about exclusive possession. But we're going to come back to the balancing of the hardships test later because it applies to some of the other remedies we're going to talk about. Next, let's talk about stay-away orders. When people think about orders of protection, this is typically what they think about, or restraining orders. This is what they think about. Stay-away order requires the respondent to basically stay away from the petitioner. It can be within a certain geographical radius of the petitioner, or it can be staying away from the petitioner's work, school, or residence, or other specific locations. It can also prohibit the respondent from having contact with other protected parties other than the petitioner, like the petitioner's minor children. If both the petitioner and the respondent are at the same school or workplace, a stay-away order can require the respondent to change schools or change workplaces. So a big issue that comes up in litigating these orders is once a stay-away order is entered, if the respondent is required to stay a certain radius away from if the respondent is required to stay a certain radius away from the petitioner, how does the court determine whether the petitioner has violated that order? I'm sorry, if the respondent has violated that order. So if the respondent accidentally comes into proximity of the petitioner, are they in trouble? So we'll talk about the factors that courts look at to determine whether a stay-away order has been violated. And this is particular to public areas. So 1 is the size of the public area. 2 is the number of other people that are present. 3 is the reason that the respondent was present at the public area. 4 is that the length of time that the petitioner and respondent were together in the public area. And 5th, and probably most importantly, is whether the respondent knew or should have known that the petitioner was going to be in the public area. So the respondent's not going to get in trouble for accidentally being in the same mall as the petitioner if there were a bunch of people there and the respondent had no reason to know that the petitioner was going to be there. You're really trying to prohibit intentional contact between the parties. Stay-away orders can also prohibit indirect contact. It doesn't have to be direct physical presence. They can prevent indirect contact between the parties, such as phone calls, mail, email, letters, and contact through third parties. So you can't send your friend to harass the petitioner if you're the respondent. That may still be covered by the stay-away order. And again, stay-away orders are not going to penalize unintentional contact. So we've talked about exclusive possession, we've talked about stay-away orders. Now let's talk about other remedies that are available and kind of what it takes to get those remedies. 1 is counseling for the respondent. Another is exclusive possession of personal property like vehicles. So you do the same balancing of the hardships test that you do with real estate that we talked about earlier when determining whether to award exclusive possession of personal property. The risk of future abuse versus the hardship of giving up that personal property. The court can adjudicate parenting time and responsibilities in an order of protection. They can adjudicate the payment of child support and maintenance that's required under the law. But for this and for some of the other remedies we're going to talk about, personal service and a hearing are required, and these remedies this remedy isn't available for emergency orders of protection that don't require personal service and a hearing. They can, again, after personal service and a hearing, order monetary damages. And they can also do prohibition of entry of a shared residence while the respondent is under the influence of alcohol or drugs. That one doesn't require personal service and hearing. It is available for emergency orders of protection. The court can order restriction on possession of firearms. This also requires service and a hearing, can't be available on emergency orders of protection. And finally, the court can order injunctions. Injunction is a court order requiring the respondent to do or not do something. So it's just rather than monetary damage, it's specifically requiring the respondent to refrain from doing something or to do some action. The test for whether an injunction can be ordered is whether the injunction is necessary to prevent future abuse or in order to effect another remedy that the court has ordered. In issuing an injunction, the court's going to apply the balancing of the hardship test that we discussed earlier. The hardship of complying with the injunction versus the risk of future abuse if the injunction isn't entered. So the bottom line is there's a wide range of remedies. The goal of the court is to protect the petitioner from future abuse by the respondent, and there's a vast range of remedies that the court can order in order to effectuate that, and it really depends on the circumstances, how the respondent and the petitioner's lives are interconnected, and if there are children involved. So the court will kind of fashion a specific remedy that makes sense for their lives. But exclusive possession and stay away orders are the biggies that often get litigated. If you have any further questions, feel free to give us a call. We're happy to help with this sort of thing. Thank you so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.